Item 1.
Lordship, I beg to mention item number 3, Lordship, CD is not received.
Okay, CDS call for if not received, issue reminder. When do you want?
Next week.
Huh? Next week. List the matter on next week, date 28.
Item 1.
Wait, please, Your Lordship. The
Yes,
person is arrested on 18/9/2024. A case is pending, session special POSCO case number 811/2024.
Okay, we'll issue notice there.
Yes, Your Lordship. TCR may be called for, Your Lordship.
Yes, Lawyer Counsel Mr. T. Davis is present. Nolo, Niki, where is the Nolo? Lawyer Counsel Mr. T. Davis is present for a petition of list. Lana Additional PP Mr. R. Kaushik is present for the respondent state. Issue notice to the respondent to the private respondent number 2. Returnable on date. Shall we fix a date?
Yes, Your Lordship.
Date
20th February.
20th bis 20th February. Meanwhile, call for the scan copies. This is under investigation or?
Yeah, this is charge is framed, Your Lordship. Yes, sir, examine. TCR. Right, correct.
Scan copies of the CD.
Obliged, Your Lordship.
We are hearing item 2.
You have CD?
Yes,
Scan copy, madam.
Scan copies.
Your Lordship, last order is page 47.
But scan copy received, but the scan copy is up to date till the date of perhaps
But
April or May. madam.
we have already given the order sheet, my lord. I think that will may help. Kindly see your Lordship's order, page 47, last RDA order, rejection order.
Page?
Page 47, the rejection dated 30/6/25. Out of 22/4, PWI examined. Till today, my lord, no progress, not a single witness examined. Till 36, your Lordship. It will be given. I'll be here. Upper liquor of my. Amga
302.
302, 376 also.
Reckon,
Just for handwritten. Our whole case is, my dear Lordship, how long? 1 year, 9 months. 22 already, my lord,
There's a
22.
new judgment also, no?
Yes,
Stated,
later judgment is also there.
holding the Vihan Kumar judgment.
Oh, that is there, my lord.
no, my learned senior friend is talking about prolonged incarceration.
Hmm?
There's one more judgment upholding Vihan Kumar judgment, circulated judgment.
Yes.
I don't know.
Mihir Rajasthan,
Me writing it.
yes, Mihir.
Well, that aspect your lordship has already dealt with in this case. Lordship may kindly peruse the order, rejection order, my lord. Now,
No, no, I am not on that, my lord. Now your Lordship, my lord, 36, your lord, can decide. For the 6-7 months
How
already
many
done.
years we are behind bars?
1 year 9
1 year, 9 months.
19 days.
And from the last year, Lordship's order, not a single witness was examined. Yes. No, no, no.
1 year, 9 months. What is the contraband?
Not contraband, my lord. Please go to.
Murder case.
rape and murder.
Please go to. Mihir, my lord, that also I am having, my lord. The latest one
Mihir.
judgment which your Lordship is talking.
That is regarding grounds of arrest. That aspect
So
lordship
that
has-
is also there, my lord,
that
here.
is already
That
What
also,
do we write?
yeah, that also one of grounds we have taken, my lord.
At that time.
Both. At one time it was not there, my lord. Subsequent Ahmad Mansur also, another case also came. After Bihan Kumar, after Mihir, after Purke, to my lord.
Ahmed what?
Ahmad Mansur we are having, my lord. It all are subsequent one. Grounds also, your Lordship, kindly see grounds. Page 51. Now, my lord, I think it will, how much time it will take, I don't know. On that ground also, 47, 48 is a complete violation, my lord. Simple information will not do, my lord. It is simple information. The latest judgment is my lord, it is dated
January.
January 6, 2026, also another reason. That is 17 months. Supreme Court said that without nature of the offense, my lord, 17 months.
What is the FIR?
Yes.
What is the case against you?
You might have relative, that is nephew and
No, no, Arvind, what is this paragraph? Have you marked the paragraph?
yes, it will latest to.
Paragraph 15.
There are 15 and 18 years.
Okay.
The latest one, January, this January, 6 January. 6 January. Paragraph 15
And
and,
last rejection order is on,
huh?
last rejection, my order,
Your lordship order is
page
36,
47, no?
30, 30.
Page 30,
No, page 47.
page 47.
Four examined and 4 Ws. Thereafter,
Since then,
not
not a single witness has been examined.
Keshigadde, your lordship referred, that is the. Mhm. But nothing is there, simply information, my lord. Even no substance offense also not given. Page 51.
This is along with 376 also.
Yes, sir. Subsequently it
I
came.
do not remember.
FIR, it is not there, my lord. Subsequently 376 for. Own, my lord, husband died and allegation is that one own nephew. Anyway, my lord, I am only on that here, my lord. 1 year, 9 months already, not a single, my lord, witness examined. I have got order sheet, kindly see my order sheet page. Your lordship, I have given pages.
Not a single witness has been examined. Four
Four
witnesses have been examined, no?
That, the day when your lordship passed the order, and that time same thing was there. My page 65 on what, kindly see my. Page 65 on what. Page 65.
Yes.
Just have a look, page 65. Your lordship rejected on 36.
Mm.
So first, after your lordship order is 4725.
Mm.
So from 4725, you'll kindly see next up to page 60, 70. All absent. And handwritten also I have given latest one, my lord, handwritten.
Okay, all right.
Yes.
Why, what is your objection?
Well, first of all, just 1 year, 9 months, my lord. Supreme Court has not defined what is prolonged incarceration, my lord. It is case specific, my lord. There are two things, my lord. One is prolonged incarceration, and there is no likelihood of ending the trial, my lord. And the offense, nature of offense has to be dealt, my lord. In Sharjil Imam case recently, 5 persons were granted bail, 2 persons were not granted bail. Your lordship knows that
Yes.
judgment, my lord.
Mm.
There also this plea was taken, my lord.
Mm.
So, my lord, the specific act committed by the person specific, I mean, that has to be looked into, my lord.
The Umar Khalid's case.
Yes, my lord. And
You have
second
that
thing,
order?
right now I don't have because it's bulky, my lord. And second thing is that your lordship may kindly go through your lordship's earlier rejection order, my lord. Your lordship has already dealt with in this those issues regarding section 50, 58, my lord notice. Now, if your lordship takes a different view, it will amount to reviewing your lordship own order, my lord. That, my lord, your lordship has specifically stated that the grounds of arrest has been communicated properly, my lord.
This
That
is not
issue-
the only ground, my lord. I have
No,
taken
but because my
one
landlord,
incarnation.
because my landlord senior has taken 2 grounds, so I'm taking
So
2
one
grounds, my lord.
ground mainly incarnation.
That an incarceration, my lord, there is no specific time period framed by the Supreme Court, my lord. That, my lord, let me submit, sir. My lord, in that respect, initially the Muhammad Muslim case was there, your lordship knows, my lord. In Muhammad Muslim case, in 7 years, out of 30 witnesses, only 5 or 7 witnesses were examined, my lord. There, Supreme Court stated that, my lord, 2 things, my lord. One, following incarceration, and there is no possibility of concluding the trial, my lord. At that stage, my lord, in this particular case, has not come yet. And lordship may kindly also look into the offense, the barbaric manner, the way the offense was committed, my lord. At this stage, your lordship only see prima facie because the trial is going on, my lord. I will not comment into whether regarding trial, my lord. So that prolonged incarceration aspect, my lord, at this stage will not come. Supreme Court might have given in, my lord, in 17 months or 2 years, in some cases 5 years, but depending on the facts of the each case, my lord. Supreme Court has not said that, my lord, yes, this is the, my lord, borderline. After that, if you cross, it will be amount to prolonged incarceration. So, my lord, there is no specific time, minimum time, my lord, which we can say that if you cross this, it will be amount to prolonged incarceration. That will depend upon the each fact of each of the case, my lord. So here, lordship may kindly peruse the record, my lord.
Yeah, I'll need
And
to
my
write
lord,
because I
yes.
think that record, this is the record, no?
But the record, my lord,
This is the record or that is the record? Okay.
the
Okay, I'll
record,
need
my lord,
2-3 days time.
Yeah.
I'll need 2-3 days time to
Yes,
go
Your
through the
lordship,
records.
your lordship. My one question, my lord, friend says, my lord. My question, my lord, not only 47, that I have stated because I have seen, my lord, and it is not a review of your lordship. Second time we are coming, my lord. If your lordship find my case is that, my lord, on 36, your lordship passed the last order. No progress of the trial. Nothing is there, my lord. How long? Article 21, your lordship, kindly say page 15 of that, just latest one, my lord. Your lordship will see, my lord.
No, that 47, I won't be able to deal with that 47 because I have already.
No, 47, I'm not on that. I'm not on 47, my lord. I'm simply on it is well, just one paragraph, just to another.
Which one?
Latest one, 6-1. 6-1-26.
Arvind Dham.
Yes,
Where?
just my lord, paragraph 15, last bottom, your lord, kindness, my. No,
Where
no,
15?
there are hundreds of thousands of cases regarding Article 21 prolonged incarceration.
I'm on
The
21.
only thing I am asking, my lord, whether Supreme Court has fixed one particular
No,
day.
not at all, my
No,
lord. But
that
it
is
is your
that is
lordship
only
is to
thing,
see,
my
my
lord.
lord. Supreme Court has given 17 months, one way,
Yes, my lord.
Nitin Adhikari, your lord, one year, 6 months. Then another earlier one. Then Sujit Tiwari, 1 year, 7 months. So it all depends, my lord. It
Depends,
is
my
not that, my lord, after 15 months, you are also able to give.
Yes.
That is not the case. I am not saying, my lord. I am saying, my lord, that on the face of it, there is prima facie there is no progress of time. How long he will be there? And by this time, 1 year, 9 months, it is well settled, bottom, my lord. It is well settled that if the state or any prosecution agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, as enshrined in under Article 20 of the Constitution, then the state or any other prosecution agency should not oppose the bail, plea for bail, on the ground that the crime committed is serious. That is, it is very clearly it is stated, my lord. And the Sarojini Mami is a threat to country. How it comes here, please do too, my lord.
Is
Something, some limit is there to the PP, my lord. What case
Please,
is referring,
yes,
which case?
No, my lord, not man.
These are two
My
cases,
lord,
one is Sarojini Mami is coming.
my learned senior has misunderstood or perhaps could not understand what I have said, my lord. My lord, the thing is that I'm saying the ratio of,
Anyway, my lord,
my lord,
I
the thing
refuse
is
to
that
speak, my lord.
there are hundreds of cases. Your lordship has passed the order regarding, my lord, prolonged incarceration.
Yes,
Article 21, I know what is Article
I am not
21.
on 147, 48.
Yes, my lord. Article 21, I know what is Article
47,
21.
48 you
But
also
Article 21, when it will come, my lord? That your lordship has to look into. And these facts are different, my lord.
After 2-3 days, I'll pass an
Up
order.
to your lordship,
I'll need some
it
time.
is closed, my lord. Disposed.
Huh? No,
Huh?
not this.
Again, it will come.
Pass an order on that day. I'll fix a date, I'll pass an
Only
order.
thing is that, my lord,
Again, my
that
lord, we have to
here,
wait for 4 PM, my lord. We will wait for 4 PM, my lord. Your lordship, division bench. For me, it become problem, my lord.
then lordship may fix it next week.
No,
No, I'm not saying, my lord. Your lordship may give order, my lord.
No, always it will not be at 4 PM division bench. How, I don't know, every day it won't be at 4 PM, I'm sure.
Day after tomorrow. Day after tomorrow. That case.
No, I have some, I have.
22 is the last court, man. He is in custody,
some
man.
work, I have some work.
He is in custody, man.
I know, I have some work, but you see, I have some work. This is also an urgent matter, the other works are also urgent.
No, that I am not saying that I
Yeah.
should get preference.
And next week, maybe I won't get a DB, you never know. If I won't get a DP, then early in the morning, first half, I'll pronounce the judgment. And if I'm in the DP, then unfortunately, if I in the DP, then.
But I am saying, my lord,
Wait,
if
wait,
your lordship pronounce judgment, I
not
may not
for
come.
you.
I may not come, my lord. If you only it is.
He'll be there, no?
Yes, that is what I am
He will
saying.
be there. Okay.
Hmm?
Arul Sanidhi?
Length of detention only, my lord. And other two judgment also there I am giving.
No, please.
Your lordship knows it, my lord.
No.
No.
It's become very burdensome.
Your latest one I have given, my lord. That will do, my.
नहीं लिस्टको तारिख नालागे म फिक्स কৰি দিম অৰ্ডাৰ ডেট এটা তাৰিখ হলে অলপ দিগদাৰ হ'ব অলপ দেৰি পিছত মই চাই লওঁ দুটা অৰ্ডাৰ কৰি ল'বলৈ আছে তাৰপিছত ক'ম
Yes, obliged, your lordship.
I'm extremely sorry, Your Lordship.
দুটা অৰ্ডাৰ কৰি ল'বলগীয়া আছে
I'm making a mention with respect to item number 1 of today's case, Your Lordship. Unfortunately, Your Lordship, the respondent number 2 has not been made a party. So, Your Lordship, may I pray that I may be allowed to withdraw this
or that
bail application? Yes, Your Lordship. I will file a press one, Your Lordship.
I thought the party has been made, so I did.
No, I understood, Your Lordship. I'm extremely sorry. I apologize again, Your Lordship.
So if you want to change for the learned council, you will withdraw and you.
I will withdraw and file a fresh one.
Learned council, Mr. T. Deori has prayed to withdraw this petition. Learned additional people, Mr. R. Kaushik is present. Petition is disposed of on withdrawal, dismissed on withdrawal.
Yes, Your Lordship. Deeply obliged, Your Lordship.
I will report for order.
Respondent number 2 party koranga etu.
May I please, your lordship? Lordship, here we have filed this IA for correction of order dated 9/10/2025, lordship. So here in this case, my lord, the petition was filed by the complainant. This is a case of NI.
25 where?
Lordship, in
Which
the
case?
para number 10, my lord. Para number 10, instead of mentioning it,
Your logo record to us. Para number 10.
para number 10, my lord, instead of mentioning that I have also considered the submission that the petitioner has submitted, it is ought to have been respondent, my lord, because it was our case that we have paid another amount of rupees 16 lakhs apart from the check amount, that is 1.61 crore, my lord. That was our case. Mistakenly, it has been mentioned as petitioner, lordship. They were the complainant was the petitioner, lordship. Accused, we were for the accused, we were the respondent. Our case was that, my lord, we have also submitted the bank statement along with our affidavit in opposition, my lord. That is the part of the record. Lordship may kindly have a
Check
look.
and I'll correct it.
Only that part, my lord.
Yes, yes.
Instead
Your
of
name?
petitioner, Mr. P. Das, lordship.
And the other side is not present.
Lordship, their name has been reflected in the cause list, but
Okay.
they are not present. That may be done, my lord. That is the, we have already submitted the
Okay,
bank
okay.
statement and all. That is the part. of-
Learned counsel, Mr. P. Das is present for the applicant, Pawan Kumar Singh.
Lordship,
Pawan Kumar Singh, whose of this application is filed with prayer to, this application has been, this application has been filed with prayer to,
correction of order dated 9/10/2025, lordship. In para number 10. Para has been specifically mentioned.
in prayer to allow correction of the typographical error that have occurred in paragraph number 10 of order dated 9/12/2025 passed in criminal petition number 610/2025. Full stop. The name of the learned counsel for respondent, Mr. M.K. Das, is reflected in the cause list, but the respondent is not represented today. Full stop. The petitioner, the applicant was accused of which case?
Lordship, the NI case, my lord. NI case number, sir. CR case number 6792 of 2022, my lord.
CR case number 6792
92.
of 2022.
22, my lord.
Full stop. On 9/12/2025, both the parties.
Lordship.
Okay.
Their 143A petition was dismissed, my lord. Against that, they have preferred this criminal petition and we are respondent. And it was our case, my lord, that we have paid an additional amount of rupees 16 lakhs apart from the check amount, that is 1.61 crore. To substantiate our contention, my lord, we have also submitted entire bank statement. That is the part of the record along with the affidavit in opposition, my lord.
that paragraph ten must contain what?
Lordship, it is in para number 4. Lordship, may kindly have a look at para number 4 of our petition, my lord. Page 4, para 4, my lord. Page 4, para 4. Lordship had got it. I have also considered the submission that the petitioner has submitted.
You are the accused.
Lordship, we are the respondent. I am the accused and we are respondent because they have preferred the application, the criminal petition.
They have preferred an application for quashing.
No, my lord. For quashing of a particular order, my lord, that is the dismissal of their petition, which was rejected by the learned trial court, which was filed under section 143A, praying for 20% of the interim relief of the check amount, my lord. That was their case. So lordship was pleased to set aside that particular order, and but it was reflected that the petitioner has submitted. It ought to have been respondent has submitted. That amount was paid to the petitioner, my lord. So in place of
Just a moment, just a moment.
lordship.
The amount has been paid to the petitioners.
Lordship, that was our case, my lord, and that, if your lordship can kindly have a look at page 51.
Just a moment, I cannot get the grip of the case. I have forgotten your case. I have absolutely forgotten your
If your
case.
lordship allow
So
me,
I'm
then,
reading the entire story
oh,
to
lordship,
get a
lordship,
grip of your case.
lordship.
So you have deposited rupees 16 lakhs.
No, my lord, that is not the case. Lordship, they have filed one application under section 143A,
Mm.
praying for 20% of the check amount, my lord,
Mm.
before the trial court. Their petition was rejected,
Mm.
and then they have preferred this criminal petition, my lord.
Mm.
We were the respondent in that particular criminal petition, and we were the accused in the NIA case, my lord.
Mm.
Thereafter, lordship, we have filed one objection
Mm.
against the criminal petition.
Mm.
In our objection also, in para 18, my lord,
Mm.
page 51, our stand was that the entire check amount was paid.
Mm.
Apart from the entire check amount, we have also paid an additional amount of rupees 16 lakhs to the petitioner. So they do not have any prima facie case. Accordingly, their petition was rejected by the London Trial Court. So we make the same submission, my lord, on the day of hearing, my lord.
Mm.
Same submission was made. Lordship was pleased to note the same our submissions from the both the sides, and subsequently order was passed. In the order, my lord, instead of petitioner, my lord,
Mm.
instead of respondent, in para 10,
Mm.
it was mentioned as petitioner. And in the last part, my lord, will kindly see, in the last part, I have also considered the submission that the petitioner has submitted that the entire check amount with an additional amount of rupees 16 lakhs has already been paid to the respondent.
Mm.
So it ought to have been misplaced, my lord, vice versa. Initially, it ought to have been respondent. In last part, it ought to have been petitioner. Because that is our stand, my lord. In our affidavit in opposition also, we have taken the same stand in our objection.
Okay.
Because they are
I'll
not going to
collect
pay us
details.
any amount, my lord. Because we are supposed to pay them.
কি লিখিছিলা তুমি লাষ্টৰ পৰা? Hmm. 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 আৰু পঢ়ি দিয়াচোন। লাষ্টৰ দুটা লাইন পঢ়ি দিয়াচোন।
Instead, we just is present for the applicant, which we are going to allow to correction of the certificate error in place of 10 of the order is 9/12/2025 passing criminal petition number 610 of 2020.
To stop, it is submitted that at para 10 of the order dated 9/12/2025, comma, instead of typing as petitioner in place of respondent, the order ought to have been typed as within inverted commas. I have also considered the submission that the respondent has submitted that the entire check amount with an additional amount of rupees 16 lakhs has already been paid to the petitioner. Okay?
Lordship.
Inverted commas closed. Bolded likhi diba ekhini ha, inverted commas full stop. Thereby, considering the submission and after going through the order dated 9/12/2025, comma, it is ordered that the para 12 may be correct, para 10 may be typed and corrected as within inverted commas ako likhi diba. I have considered the submission that the respondent has submitted that the entire check amount with an additional amount of rupees 16 lakhs has already been paid to the petitioner.
Petitioner, my
Full
lord.
stop.
That will do.
Thereby, the para 10 is corrected and this order will form a part of the order dated 9/12/2025 in criminal petition number 610/2025.
Lordship.
Okay.
Lordship. Deeply obliged, lordship.
Mm. in terms of the above observation, DI stands disposed of. Otherwise, you won't be able to file the fresh petition under section one.
They will be filing a fresh petition.
They won't be able, it's for their benefit only, but they are
Why
not
not?
present today. It'll liquidation, I have, the,